Okay, so today I'm going to look at the power of the European Union. So what laws they can do and apply. We've got to remember the European system is a juridical system, and so is the Italian system. They're both judicial systems, and we can't have two judicial systems on the same level. One's got to be supreme. Otherwise, what laws do we respect if the Italian judicial system says one thing and the European says the opposite? Which laws do we respect? Always there must be a sovereign, a supreme judicial system. And if we look at what the Constitutional Court has said, and I talked about this earlier, it said that the European judicial system must be supreme, and it's also stated that they must be coordinated at the moment of their application by the judges. So if an Italian judge sees a European law and an Italian law, it must be coordinated at the time of the application. They can't be decided, if you like. So the Constitutional Court has ruled that the principle of direct application conforms to the Constitution. So there's, in the treaties, you've got the regulations, and they are directly and immediately applicable to every member state. That means they don't even have to be received by the Parliament. They don't even have to be approved by a national Parliament. They are automatically received as immediately and directly applicable. An example would be the regulation of cigarettes having pictures on the packets to warn us, pictures of horrible contaminated lungs with tar and toxins. That was a regulation, and that was immediately and directly applicable. So when they made that law, when it became binding, vinculante, it was binding in all 27 member states, also England 28. And the Constitutional Court says that's okay, because we've got Article 11 that consents to the limitations of sovereignty. Obviously, this is an act of sovereignty. By having a power, the European Union able to apply its laws directly and immediately on the territory without the consent of the Parliament, without the approval of the Parliament, Italian Parliament, this is a sovereignty. But Article 11 does state that Italy consents to the limitations of its sovereignty. We know that from our past dealings with Article 11, and not obliges but consents. If it wants, it can consent to that. Obviously, Article 11 also says this must be done in a way that where you've got parità con altri membri, with others. So Italy must, be present in the Parliament when they're making the laws, or in the Council of Ministers, or in the Commission where they're applying the laws. So it has, and it's not being subordinate to other countries. It also is part of the process of making the law. Okay, so in this way, it's excluded the questions of compatibility with the Constitution. It's by looking at the Constitution and seeing Article 11, which is a fundamental principle, which is a supreme principle, more of a higher level, supreme, over the other articles. This means that there can't be a question of compatibility with the European Union rules. We must always accept them, and the Constitutional Court won't judge them. And if you know our Constitution is not adequate, then it must be changed to comply with the European Union. Obviously, with the European Union, you cannot be a member if you don't comply with the European laws. So there's an inbuilt need. We look at Poland, for example, who are violating the treaties by having really political representatives controlling judges and able to choose and sack judges. This is against the spirit of democracy, which is written in the treaties. Poland could lose its membership of the European Union because of this. We need to have European law supreme. So then we say, if an Italian judge is confronted with a community law in contradiction to an Italian one, the European law must be applied. There's no questions of that for the Constitutional Court, which is the highest court in the land. So if that's the case, if the Constitutional Court's role is just to guarantee the correct application of the Constitution, how is this possible? What is it judging? If it's not to judge the laws, are they complying? So it's not guaranteeing the laws are actually constitutional. But the Constitutional Court interprets the Constitution and must decide the reasonable interpretation of articles which are general and ambiguous. So they've got to look at the Constitution and really, I mean, it says, the Constitution says the people are sovereign and must act within the limits of the Constitution. But the Constitution the people have given that sovereignty, shared that sovereignty, or loaned that sovereignty with their representatives who have signed up to the European treaties, which has become international law. So there is this case of we have consented to the limitations of our sovereignty, and Article 11 really demonstrates that we can consent, and if we do consent, Italy always respects international law. We can look at Article 10 of the Constitution, where it says Italy conforms to international law, and treaties are international law. They become international law, and so we must respect them. So this case of should the Constitution be higher, be more supreme than the European law, has already been deemed as false, and not, we can't put the Constitution higher. And the Constitution Court will not judge this. Also, from Europe, there is a Supremacy Doctrine. So the European Court has ruled. There was a case of Costa versus Enel in the past of 1964, and the Constitutional Court, not the Constitutional Court, the European Court held that where there's a conflict between the members of national states and the European Union prevails. This was a case where Enel wasn't able to do something because of European rules. It was restricted by European rules, and there were Italian rules that were actually in conflict with this, saying the opposite. And Costa decided he wanted to test this and believed that the national rules should prevail, but the European Union said the opposite. So there's that precedent from both sides, the Constitutional Court and the European Court have said that the European Union laws are supreme. You've got this Supremacy Doctrine, so it creates a vertical federalism. You've got a kind of autonomy of states and independence of states, but that must act within a federal system, so they are limited of their actions. They can only do act within the law of the federal states, within a system of horizontal separation. So yeah, like I just said, they're independent. There's this horizontal separation and vertical federalism. So we do have states that are equal amongst themselves. The sources of European law, you've got the regulations, or first of all we've got the primary law, which are the treaties. Again, treaties are international law. To make a treaty, all the member states must agree, so it's unanimous. It's not majority or aggravated majority, it's unanimous. And these are the real, constitutional aspects of Europe, because they establish what Europe is, the institutions, what they do, what areas Europe have competencies in, maybe in work or in consumption or in the environment, etc. All these, how the system works, with human rights. Even the Lisbon Treaty established a binding Charter of Human Rights, all established by treaties, so these constitute. There was I spoke before about a constitution of Europe, and the French and the Irish didn't want a constitution of Europe. They wanted, in a referendum, in their referendums, they rejected this idea. So Europe established the Lisbon Treaty, which is a kind of bringing together a unification and an establishing of Europe as a legal entity, and a kind of constitution in all but name. So the treaties really do constitute Europe. They bring it into being. So it is a kind of constitution without that name that is quite heavy. People are quite attached to their nation states and their national constitutions. And I think they didn't want the idea of a constitution. So that's the primary law. They can never be violated. Very serious for these to be violated, these rules, because they establish the identity, all the values. Secondary law are the regulations and directives. directives. We can see these in terms of ordinary laws in Italy. These secondary laws, you've got the regulations which are made by the Parliament and applied by the Commission as being immediate and directly applicable to the member states, and then directives which are indications to member states to change their laws. So each state can change the laws the way they want, but it does take the national parliaments to write these laws. Maybe, for example, a directive could be to stabilise work after 3 years of working in a specific place. There was a law that stabilised this, says all member states must stabilise the workers and can do it in their specific way. They can do it in their unique cultural approach. So these are directives. They're a way of harmonising the systems. Remember, we want integration, so we need to create harmonised rules. Certain rules must be applied to all the states if we are to have one system. And those are directives. Generally, we can imagine that regulations and directives exist to put the treaties into effect. So the treaties will be looked at by the Parliament and also the needs of Europe, and they need to put these into effect with regulations and directives. You've got supplementary law. This is case law by the Court of Justice. So this is like the English system where, past decisions, past sentences can have a weight, do influence other judgments, or do give indications. The way we dealt in the past with certain situations will give an indication of how they are dealt with in the future. That's case law. Supplementary law also could be international law. Maybe there's an international law that the European has done a treaty with I don't know, America, maybe a trade treaty, a free trade treaty, and that becomes international law that the European Union must respect. So that's considered supplementary law. Or you've got general principles. You've got certain principles that the European Union always respects, like subsidiarity. Subsidiarity is when a lower level, if something can be done better at a lower level, it must be done better at a lower level. So for example, if it's better that the local community decides if they need a road or not, it won't be the European Union deciding we need a road. It's better decided on the local level, etc. All sorts of decisions are better at a lower level. Obviously, the more global the problem or the need, the higher up the hierarchy the decision will be made. If we're talking about the environment, we're talking about a global problem, the European Union will make that decision. It can't be local level when we're talking about global problems. So that's important. Human rights, proportionality. Proportionality is a principle also in international law where we respond in a proportionate way. So if, I don't know, England doesn't respect the treaties with the withdrawal treaty, then we respond proportionately. We don't, suddenly stop all types of trade and relationship with the United Kingdom. Maybe we put some tariffs on, or we have a little bit of sanctions. It must be proportional. And any necessary and appropriate action is another principle, supplementary law. So anything that really needs dealing with, maybe, and immigration could be a problem if something happens in a war in Syria again, and lots of immigrants come. Then there might be necessary and appropriate action, and that would become the supplementary law. Okay. Decisions. These are legal instruments which are binding on individuals, generally on individuals that they are directed at. So maybe the European Court may make a decision about Facebook and paying taxes, or Google and paying taxes, and these are decisions and they are binding, vinculante. So it could be on individuals, but it could also be addressed to member states if they make decisions. There can be recommendations that are not binding, but they can be directed at individuals or member states too. So, okay. So if we look at the secondary law, so the regulations, these are, the European regulations are general, so that means they apply to all member states. Remember, we're all equal in front of the law. Rules must be general and abstract, if we remember, go back to the beginning. And they are directly and immediately applicable to the member states. If they're clear and unconditional, sometimes they're not clear and unconditional. And so it's, in that case, they may need to go through Parliament and be interpreted, or maybe even referred back to the Court of Justice, if they're not clear and unconditional. And then directives is also a secondary law. They commit the government to formulate regulation. Generally, they're to harmonise, and this takes time. This means that it's got to go through Parliament. The law must be discussed and voted on, etc. So they're not intended directly for citizens, but for member countries, member states, which must apply them through their systems in the way that they want to be done, to be written. So each member state may write a law that carries out the instructions of a directive in its specific way. Okay. Yes, it's very important that they're done. The directives are made before a specific time. So there's a prescribed time for a directive. If they're not done in time, they can be sentenced by the Court of Justice. And Italy has had this problem in the past, where every European law, because of our slow system, we've got two houses of Parliament, the Senate and the current Deputati, and a lot of maybe unstable governments, etc. Many times in the past we haven't applied directives in time, and we were fined because of it. We had to pay a fine. So there is this community law Italy adopted a special instrument called the Community Law, and this delegates European directives which must be applied. So the governments can write them. They can write it, and it can be applied as soon as possible with a decreto legislativo. So with this instrument, the government can write it, and then it gets applied, and then after, the Parliament's got 60 days to approve this decree. And it doesn't need to go to Parliament, be written, be amended, discussed, voted, amended again, come back to the etc. And then a government falls, etc. etc. So this instrument means it becomes a decreto legislativo, and the government write it, and it has the forza della legge. Atto della legge. So that has resolved that.